mother of the victim.
Yes.
He himself stated that घटना के 1 महीना पहले गाड़ी को लेकर पतित से हमको झगड़ा हुआ था, and which is corroborated with the 313. And in 313, my lord, this appellant and victim relationship is a brother and sister.
What the counsel for the applicant, how the counsel for
But
the
Lordship, victim is of 8-year-old and she has stated in his.
We are rejecting it.
Oh,
Please.
Lordship.
The counsel for the applicant reduced the prayer for bail of the applicant on the ground that he is in custody since 27/9/2014, and the sentence awarded is for 14 years. Next paragraph. After hearing the counsel for the appellant, we have gone through the record. We find that the appellant is convicted under section appellant has been convicted for committing offense under section 6 of the POCSO Act. Full stop. The PW2 is the minor girl who was raped. So she is aged about 8 years. In her statement, she has completely supported the prosecution case and implicated this appellant as the perpetrator of the crime. So considering the aforesaid fact which surfaced during trial, we are not inclined to release the appellant.
For hearing, my lord, any?
Liberty is reserved the appellant to pay for early hearing of this appeal.
Serial number 6, Criminal Appeal DB 1279 of 16, Mr. Akashdeep, Mr. Panchvat.
Milords, I appear, Milords, in this case. So far as the last IA that was rejected was on 16/9/2021, Milords. I have two grounds, Lordship. First one is that now both the appellants have completed 10 years in custody, Milords. That is one of my first ground, Lordship. Secondly, Lordship, the trial court has convicted the appellants on the basis of the testimonies of 3 family members.
That is over.
Yes, Lordship. No. I just want to place one thing, my lords, that from the what has been submitted, what has been testified by the witnesses in the LCR has not completely been written in the judgment, lordships, because from
month of September 2021.
yes.
Did you take any steps for early hearing of this appeal?
Milords, so far as
No.
Milords, only one submission, Milords. One submission, Milords. They have completed 10 years. Secondly, Lordship, so far as Lordship had rejected the...
Not on merits. Merits we have already rejected, Your Honor.
But in the LCR, Lordship, what has been stated by the prosecution witnesses...
Mr. Counsel, we are already rejected on merits, and if you are appealed by that rejection on merits, you should have approached.
Actually, Lordship, last time I had not argued this matter, but I found that there are certain things which were not placed before your Lordships, my lords.
The prayer for bail of this appellant was rejected only on 16/9/2021. The petitioner has renewed his prayer for a span of 6 months. The appellant will give it. First up. This is his what attempt? Third attempt or fourth attempt?
In para 2, I have stated, my lords, of the IA.
This is the fourth attempt.
Yes, earlier it was rejected.
Whereby he is seeking bail, considering the fact that he has his last application was rejected. Rejected on 16/9/2021 only, and he has taken no steps for early hearing of the appeal, which liberty was already granted to him. We are not inclined to reject in case of failure. This high response dismissed.
Serial number 7, Criminal Appeal DB 1302 of 16, Miss Suchitra Pandey.
Wait, please. Malus, in this present matter, we have sought for the suspension of sentence. Earlier, we had also moved, but then that was rejected by order dated 2/5/2019. The present appellant, my lord, she is convicted under section 363 and 370 clause 4, read with section 34 of Indian Penal Code. So far as 363 is considered, my lord, 7 years RI was given. Now, my lord, this appellant and the other co-accused, they were both were arrested on 20th/4/2015, my lords. And as per the judgment, they were also produced from the custody itself on the day of sentencing. So, my lords, it's around 7 years now. So 363, I'll not get into. 374, my lords. So far as 374, my lords, the maximum punishment is life imprisonment, which has been given to her. And the minimum punishment is, my lords, 10 years, my lords. Now, this 374, my lords, is for the punishment of trafficking of a minor, my lords. So far as the age of the victim is considered, my lords, in this case, my lords, I'll show from the report of one of the medical reports from the documents, my lords, that her age was assessed as around 18 to 19 years, my lords. So I'm just on custody, and that there is a doubt as to the age of the victim also, my lords. And so far as custody is already around 7 years. A few days are left, my lords. So, my lord, will kindly have a look at the report. Medical report, my lords, which is of Dr. Sangeeta Lal, my lords, where she has assessed. The radiological report was number 957, dated 21/4/2015. Number of plates such and such. Age of suspect is about 18 to 19 years, my lords. This would be part of the LCR, my lords. So I'm on that point, my lords. So far as the other co-accused is there, my lords, he's been convicted under 376. And this co-accused, my lords, in fact, in the 164 statement of the victim, my lords, she has stated that it was her mobile phone through which she could actually contact her family members, and thereafter she was released, my lords. So I have a very limited ground, my lords. But then 363 is already over, and 374, my lords, maximum punishment has been given to her. If my lords will permit, I would read out the 174 statement, 164 statement of the victim. After she was recovered, she gave her statement before the magistrate.
On what basis the court holds that the victim is minor?
My lords, they have said that the radiological report is not there on record, and apparently she did not depose, my lords. The Sangeeta Lal she did not come and depose. Her report is there on record, but she was not made a witness, my lord. She did not come and depose, I think. So her age was considered to be minor, and in fact, there's no specific record of her age, my lords. Everybody is giving different versions. In fact, all the witnesses also. Her own statement also, she says that 15 साल पहले मैंने पढ़ाई लिखाई छोड़ दिया. So that 15 साल पहले, if she leaves her, and because they are all from very backward place, my lords, so I'll not get much into what they have stated, but then the report of the doctor is assessing her to be, and the benefit of doubt, I would pray, should go to the accused. My lords?
You have completed how many years?
मतलब they were arrested on 20th 4 2015, तो अभी 7 साल हो जाएगा on 20th 4 19 4 20/4/2015 para 2 of the judgment, my lords, and thereafter she was produced from the custody itself.
So even if what you are saying, that even if what has been found in the imputed order, at best, it can be a case under section 370 within subclause 2, where the punishment minimum 7 years, maximum 10 years.
My lords, then half of the sentence she is already completed if we go by that, my lords.
No. So half of the sentence is complete, and if you go by that, only 15 or 18 days remains to complete the minimum sentence.
Yes, well,
So we are keeping this after 15th of April.
yes, my lords, then let it be that way. It can be heard on merits and decided.
Even if the court thinks that it will come under 370 within subclause 2, then also you cannot be sent back to the prison.
So we will go in. Yes, my lords, we can argue. We'll place our arguments on that point, and it can be decided.
Yes, on 3rd week of April.
30th of April. Yes, my lords.
3rd week.
13th. Yes, my lords.
3rd week.
My lords, through VC, whichever day, I would just request, my lords, if it could be heard through.
I don't know if BC or not. Honorable Supreme Court is going physical from Monday onwards.
13. Yes, my lords, 13. Anyways, if it.
It is 3rd week, not 13th. 3rd week of April.
Some specific date may be given, my lord, subject to your lordship.
Specific date not possible now.
Because bench
Every Wednesday, we
obliged.
every Wednesday.
Yes, ma'am. Obliged, ma'am.
Serial number 8, Criminal Appeal DB 1356 of 16, Mr. Virat Kumar, Mr. Gautam Kumar for the petitioner.
Yes. Who is appearing?
Serial number 8, my lord.
Yes.
This is Santosh. Yes, your lordship.
Yes.
Criminal Appeal 1356 of 16, your lordship. This sentence is under section 376, 323, and 350 of IPC. Sentence is for 10 years, your lordship. And now the petitioner has served the judicial custody for 5 years and 4 months.
And
I am custody since 21/11/2016, your lordship.
continuously.
Yes, my lord.
Where have you stated which paragraph?
Yes, my lord.
Yes. Paragraph 4.
Yes, ma'am.
The applicant prays for releasing after suspending the sentence. Full stop. Next one. His prayer, similar prayer was earlier rejected. Full stop. Next one. Now the applicant affirms that he has been sentenced to undergo rigorous imprisonment for 10 years. 10 where is it? So the 10 years for committing offense punishable under section 376 of the IPC. This offense that he is in custody since is in custody since
21/11/2016.
21/11/2016, and thus have completed half the sentence. Considering his submission, since the appellant has completed half the sentence, he is likely to be released 10,000 crucialities. Full stop. He will mark his attendance once in 4 months before the registrar. Before before the addition of Session Judge 3 Rajmahal once in 4 months, in pendency of this appeal, full stop, next paragraph, it is made clear that before accepting the bail bond, the court concerned will satisfy himself as to whether the petitioner and the applicant has already completed half the sentence or not. Full stop. If it is found that he has not completed half the sentence, his bail bond should not be accepted, and the fact should be immediately communicated to this court.
On merit, it was rejected earlier.
Yes, next.
Serial number 9, Criminal Appeal DB 1382 of 16, Miss Alpana Verma, Mr. Vijay Kumar Sinha for the petitioner.
This is application, my lord. Appellant convicted under section 302 of the life imprisonment, my lord. Earlier twice rejected, my lord. And this is a third time, my lord. Appellant and in the on merit, my lord. A study, my lord, 7/7/2014, my lord, about 8 years, my lord. And the initial FIR laws, my lord, 307 and 326, my lord. After 15 days, Sony Devi died, my lord. And then the month 302 added, my lord. Altogether, my lord, 9 witnesses have been examined, my lord. PW6, my lord, husband of the deceased, my lord, भगवती शरण, my lord. मतलब ये इसमें ये बोले हैं हुजूर गवाही में कि मेरे बहन और मेरे पिताजी प्लेस ऑफ ऑकरेंस में प्रेजेंट थे, लेकिन उनका कहीं गवाही नहीं हुआ। और ये मतलब आफ्टर 15 दिन के बाद ये इनका डेथ हुआ है सोनी देवी का, और कस्टडी हो गया हुजूर 7/7/2014, अबाउट 8 years, my lord.
So all supported the case.
क्या मतलब?
All supported the case.
नहीं वो नहीं एक्चुअली मैंने प्लेस ऑफ ऑकरेंस में उधर PW6 हस्बैंड ऑफ द डिसीज, माय लॉर्ड, मतलब हम पढ़ देते हैं 6/7/2014 की घटना है, 1:30 बजे दिन की घटना। मैं जनकपुर ये था, घर में पत्नी बच्चा था, तो मैं मेरा छोटा भाई त्रिलोकी त्रिवेणी बनवाल उर्फ रवि कुमार आया और बहस करने लगा, बोला कि मेरी बहन को कल देता ज्यादा काबिल हो गया, वक्त पगझक करने लगा था, पेट में छुरा मार दिया। ये किचन का भाग, पिताजी एवं भाई दोनों दरवाजे पर धरकर मैंने पिताजी भी थे और इनकी बहन भी थी, क्रॉस एग्जामिन में भी आया हुआ है हुजूर। मैं 5 भाई एवं एक बहन, घटना के समय बहन की शादी नहीं।
Mr. Counsel, the witnesses, non-examination of the witnesses will not help you in this case. You demolish these evidence of this PW6.
या नहीं, ये बोलते हैं कि मेरी बहन और ये पिताजी दोनों थे, लेकिन उनका कहीं गवाही नहीं ना हुआ हुजूर, इसीलिए। और ये कस्टडी लगभग 8 साल हो चुका है। नियर फ्यूचर में हियरिंग भी नहीं होगा ना हुजूर, इसीलिए इनको 7/7/2014 से जेल में है। इनको मैंने लगभग 8 साल हो गया कस्टडी, लगभग 8 साल। 8 साल बोल ही रहे, लगभग 8 साल बोल रहे हैं। ये
evidences are there which corroborates, the medical report also corroborates.
वो तो मेरिट पर तो डिसाइड हो चुका है 2 बार हुजूर, लेकिन वही है कि कस्टडी मैटर पर हम जा रहे हैं ना। कस्टडी 8 years, अबाउट 8 years, my lord.
This is the sole appellant.
Yeah, sole appellant.
So that one pray for early hearing and get your case heard.
सोल appellant मतलब नियर अबाउट 8 years कस्टडी, नियर फ्यूचर में होगा नहीं हियरिंग, इसीलिए थोड़ा सा।
The appellant prays to suspend the sentence and release him on bail. So his prayer was earlier rejected. There is a direct allegation against the appellant which has been corroborated in evidence that he has given knife blow upon the informant who later on succumbed to the injuries. Her husband also supported the prosecution case in his evidence. This appellant is the brother-in-law of the deceased and brother of the a brother of the PW,
Six.
who happens to be the husband of the petitioner. Considering the evidence, uh, we are not inclined to release the appellants on bail. This I is dismissed. Full stop. Next paragraph. The appellant is at liberty to pray for early hearing of this appeal, since he is this court convict.
Serial number 10, Criminal Appeal DB 59 of 17. Ms. Suman Tripathi.
Yes, Mr. Perry. No one appears on behalf of the appellants today. First up, on the last occasion, also, that is on 23/9/2021, no one had appeared. The name of counsel is appearing on behalf of the appellants. First up, the same counsel is appointed by the High Court Legal Services Committee. First up. Thus, the High Court Legal Services, the High Court Legal Secretary, High Court Legal Services Committee is directed to immediately nominate another lawyer who can represent this appellants. Full stop. The copy of this order will be taken back to the Secretary, High Court Legal Committee.
How about the state in this case, Your Lordship?
Give your slip. Send your slip.
Serial number 11, Criminal Appeal DB 104 of 17, Mr. DC Mishra for the petitioner.
Earlier prayer for bail of appellant was rejected on 26/4/2017. With observation may renew after 3 years.
Please.
3 years.
Yes.
This appellant has been convicted under section 302, 326 and 306 of Indian Penal Code and sentenced to RI for life and fine of ₹10,000. And he is in custody from the date of arrest, my lord, as it appears from the order impugned in paragraph 26 also. And 14/8/2012, 10 years.
So PW4 is a direct, PW4 is eyewitness.
PW4 and 7. And the conviction was awarded on the basis of PW4 and 7. But the defense witness has categorically said that their opponent, they opposed for this Abba Dabba play, and the dispute arose with regard to the objection of playing, my lord.
So you admit that there was some objection, there was some alternative.
Actually, my lord, it appears that there is no such eyewitness. And the defense witness has also given deposition, which has not been taken into consideration, who are also stated the very actual fact of the case.
He is the sole accused and sole convict.
He is sole accused. The case is that he demanded 20 rupees, then he has given, then again he has demanded 500 rupees, then they have asserted. When they denied, they asserted. Shyam Singh Munda is
But the appellant on the ATP. So the appellant has paid to renew, appellant has paid for renewal, has paid for releasing fees of him in bail. Appellant has paid for releasing him on bail after suspending the sentence. Next, counsel for the appellant submits the appellant is in custody since the sole appellant who is the sole convict is in custody since
14/8/2012.
14/8/2012. So he submits that even if the evidences are taken on its face value, this case will not fall within the purview of section 302 of the Indian Penal Code, as there was a dispute going on between the parties and some altercation had taken place, which suggests that in the heat of the moment the entire incident had taken place. Next one, be that as it may, since the appellant is in custody of so and so, there is no likelihood of this appeal being taken up in near future, we are inclined to release this appellant 10,000 after suspending the sentence, full stop, 10,000 to sureties, full stop. Next paragraph, the appellant will mark his attendance before so and so court. Register so and so. Till this once in 4 months to disposal of this.
Serial number 12, Criminal Appeal DB 571 of 17. Mr. Nanda.
Your in this case, I am appearing on behalf of informant, Your Lordship, but I don't have the copy of memo of appeal as well as IA, Your Lordship.
In this case, Mr. Majumdar is to senior advocate is to assist your lordship, but perhaps he is not well today, my lord. He is not well today.
Today, yesterday night, what happened? Yesterday was his medical day. So yesterday, he could not sit in the chamber after his problem, Your Lordship. So he could not go through the file. Today is well, Your Lordship. But yesterday he could not go through the brief, Your Lordship, after his medical problem. So only for not today, Your Lordship.
The name of the court would also.
From Delhi cause list, under the heading for orders, serial number 1, Criminal Appeal DB 1305 of 16, Mr. Anurag Kashyap for the petitioner.
Your Lordship, I am appearing, Your Lordship. Your Lordship, earlier twice IA rejected by the Lordship, and now the fresh IA Lordship filed for a suspension of sentence for the convict under section 304B and 498/34 of the IPC, Your Lordship, for the sentence 10 year, Your Lordship, and rupees 5,000 fine, Your Lordship. Now the petitioner is in custody, Lordship, 21/5 of 15, Your Lordship. He is in custody, Lordship, 7 year and 10 months, Your Lordship. She served the half of the sentence, Your Lordship.
You are in custody for?
Your Lordship, page number IA petition, Lordship, page number 5, page paragraph 14, Lordship, 21/5 of 14, Your Lordship.
Who is this appellant? Who is this appellant?
Your Lordship, petitioner is a husband. He's in custody more than 7.5 years, Lordship.
304B.
Yes, Your Lordship.
Let us see what are the evidence.
Your Lordship, from judgment page number 19, Your Lordship, para 2, Your Lordship. On the basis of detailed report of C.S. Gupta, alleging there that his sister Kanchan Devi was married with Ranjit Sav in year 2011, Your Lordship. And just after the marriage, Kamala Devi, mother-in-law, Ranjit Sav, husband, and Mangu Sav, father-in-law, started demanding rupees 1 lakh and one motorcycle in dowry and used to torture with them mentally and physically for the several times. Panchayati held, but no.
She was burned to death.
Lordship, all the witnesses, Lordship, PW1, 2, and 3, PW1 hostile, Lordship, PW2 hearsay, and PW3 Bajnas or cousins contradictory evidence.
This is 304B.
Almost 8 years, Lordship.
304B.
Sentence, Your Lordship.
The burden is upon you. The burden is shifted. Primarily, they have substantiated that there was a demand for dowry immediately before that there was torture within 7 years. Now, how have you discharged the burden?
हुजूर 10 साल का कन्विक्शन जिसमें 8 साल ऑलमोस्ट 8 साल रह गए हैं.
Yes, ABP, who is the ABP?
I am appearing on behalf of the state, my lord. The doctor has conducted the postmortem report and he.
Can't we issue notice for enhancement?
My lord.
Can't we issue notice for enhancement?
Regarding the.
The doctor has found that the death was due to asphyxia and due to anti-mortem throttling. This doctor has found burn injury, which was the postmortem in the nature. My lord.
Maybe you heard the concept of the applicant, heard the concept for the state. The applicant submits that the applicant is in custody for 7 years or more, whereas the punishment, whereas the sentence is for 10 years. We have gone through the entire records. We found that the sentence was for 10 years, is for 10 years. In the case where when there is an allegation that this appellant has committed murder of his wife, the appellant is convicted under section 304B, full stop. The doctor found that after committing murder by throttling, it was found that after committing murder by throttling, she was burned, the deceased was burned. Full stop. Considering the nature of evidence which surfaced during trial, we are not entitled to use this appellant on bail.
Any liberty may be given to Lordship.
It is there, we will move. Move for early hearing. Appellant is liberty for early hearing. You will be at the appellant for early hearing.
Lordship, हम इस आयु विड्रॉ कर लेते हैं.
Okay, after some argument, the counsel for the appellant seeks permission to withdraw this IA with the liberty to approach the court for early hearing of this appeal. They are allowed.
Serial number 2, Criminal Appeal DB 260 of 17, Ms. Jaswinder Majumdar for the petitioner.
Your Lordship, in this case, I am appearing. IA has been filed on behalf of the appellant number 1, Your Lordship, namely Muneshwar Mistry, Your Lordship. It is mainly on the age ground, Your Lordship. Now the appellant is 80 years old. 80 years old and is suffering from various problems, Your Lordship. As such, he has been convicted life for the offence under Section 302 of the Indian Penal Code. Now, the allegation, as per the first information report, is, Your Lordship, 9 persons came into the house of the informant. They dragged the issue mystery, and 3 of them, all armed with weapon, they have assaulted, and then all of them have also assaulted, Your Lordship. But there is a specific allegation. So far, these 3 persons have concerned, Your Lordship. Although one of the appellant has already been enlarged on bail by order dated 17/7/2017, Your Lordship, on the age ground, Your Lordship. Now, all this, there is a specific allegation as against these 3 appellants, Your Lordship, that they assaulted the Issue Singh, and Issue Singh subsequently he died, Your Lordship. Now, they say that there was a land dispute between the parties. Both the parties, they are the agnates, Your Lordship.
He was released because he was 85 years.
Yes, Your Lordship. He was
85 years.
I mean, he is
85.
80 is also, Your Lordship, senior citizen. I've just sent the order before, Your Lordship.
Senior citizen, which order?
No, I've just sent the order of the Honorable Kerala High Court, Your Lordship, where they say the senior citizen that time he's 70 years and there's no likelihood of taking up the appeal in near future, Your Lordship.
There is no likelihood of taking out this appeal. Have you moved for early hearing?
For early hearing, I have not filed application. I have not filed an application, Your Lordship.
Once you say that there is no likelihood of this appeal being taken up, there should be an order on an IA that you have already prayed for taking up this appeal out of turn, or you have prayed for early hearing. How do we know that there is no likelihood?
But Your Lordship, as per Seritum, that's what, because
You are saying that he is 80 years, and in paragraph number 9, you have stated 86 years.
paragraph 9. As per Aadhaar card, Your Lordship, as per Aadhaar card. As per Aadhaar card, it is 86 years. As per judgment, Your Lordship, it is 80 years.
Now tell me what is the current age?
They say the Aadhaar card, but Your Lordship, as per the judgment, because in the judgment, it has been said that he is 77 years at that time, Your Lordship. And I have annexed the Aadhaar card also, Your Lordship. As per judgment, Your Lordship, 75 years at the time of judgment, 5 years, 80 years, Your Lordship. But I have annexed the Aadhaar card also, and as per Aadhaar card, is 86 years old. I have annexed the Aadhaar card, Your Lordship. I was coming to that, Your Lordship. Aadhaar card is the ID proof, Your Lordship, but judgment is there with the...
You get. Lower merits, the prayer for bail of the appellant was earlier rejected. Yet, the appellant has renewed his prayer on the ground of age, which is more than 80 years. First up. Next. Also, for the appellant submits that one of the accused, one of the convicts having similar allegation has been released by this court as he on 17/7/2017 on the ground of considering the age of the aforesaid convict considering the age which was 85 years. One of the co-convict namely Chandradev Mistry. Next paragraph. Considering the age of the appellants, which is more than 80 years, we are inclined to release him on bail once in 4 months before the trial.
God bless you.
Serial number 3, Criminal Appeal DB 264 of 17, Mr. K.K. Mishra, Mr. Sunil Kumar Mahato for the petitioner.
May please, my lord. This is the third attempt, my lord. Twice earlier rejected. Now, my humble submission is, my lord, that 1 and 2 are hearsay witness, 3 and 4 are inquest witnesses, 5 is also hearsay, 6 is the informant come eyewitness of this case, 7 is IO, and 8 is doctor. The appellant is in custody since 4/6/2014, that is to cover about 8 years.
Now it is not completed.
My lord,
It is not completed.
pardon me, lord.
8 years not completed.
I could not listen, my lord.
8 years not completed.
Earlier, my lord, rejected twice, my lord.
I am saying that 8 years, we are saying that 8 years not completed. You have not completed 8 years in custody.
Near about 8 years, my lord, because 4/6/14 he is in custody.
Hereabouts.
And earlier there was order by my lord to renew after 5 years, subsequently again rejected. So I am not harping on merit of this case, my lord. Taking into account that admittedly there is a land dispute and PW6 informant is the only eyewitness to the alleged occurrence as stated and narrated and relied upon by the court below.
So how do you demolish it? Yes. The the doctor is the doctor is PW
8, my lord, 8. 8. He has found injuries by sharp cutting weapon.
which corroborates to the statement of PW number 6.
Informant, it can be said to be corroborative, yes, so no doubt of it, my lord. It can be said to be corroborative, but fact remains, my lord, the enmity cuts both the ways. There is a land dispute admitted.
It cut both the ways.
And since his father was murdered as alleged in the first information report, therefore also presumption has been very deep that he might have committed murder of this.
Do you have any other criminal antecedent?
No criminal antecedent, my lord. Oh, sorry, my lord. There is one case wherein it is said that the informant's grandfather was done to death by this petitioner.
What happened to that case?
My lord,
When you are habitual, mister.
Yes. What happened to that case? What happened to that case, Mr.
yes, my lord. What happened? So we are not aware of that very case, my lord.
Can you supply us that information?
Yes, I'll try my level best to furnish said information, my lord. Next date and after next week, my lord.
It has been submitted that this appellant was also an accused in a case where the murder of the grandfather of the in a case where the informant's grandfather was murdered. Next one, the counsel for the appellant submits that he will inform this court the status of the aforesaid case. This case is adjourned for 3 weeks.
Serial number 4, criminal BB 285 of 17, Mr. Anurag Kashyap for the petitioner.
Lord, the sole appellant, Lord, has filed with IA for grant of bail. Earlier, Lord, the prayer for Bill was rejected on 1/11/2017, about not more than 4 years, 5 years, about more than 4 years ago. Lord, the appellant has remained in custody, Lord, since 19/8/14. Lord, this is a case under section 302 IPC in which the appellant, Lord, has been convicted for life. Lord, in this case, 9 witnesses have been examined, but Lord, the conviction has been recorded merely on the basis of Lord one child witness, that is not the P5.
Supported the case.
Yes, my lord, she has supported the case, my lord, but she is the tutored witness. Because my lord, this has come that she was residing with my lord, her grandmother, that is not the Bhavi.
So where will she reside?
My lord, she said, my lord,
She will reside in some other place.
she residing with not the grandmother, the Dadi.
Where will she reside? What is the relationship of this witness with the deceased?
My lord, the appellant number 2 is the mother of not this PW5.
So,
case of the person like this, my lord.
and who is the deceased? Who is the deceased?
Deceased, my lord, is Nandu Singh.
What is the relationship?
Husband of Lord appellant number 2.
Husband of appellant number 2.
And Lord, the case of the person is not that this appellant number 2 was having illicit connection with appellant number 1. Yes. And on the date of occurrence, Lord, the deceased was called. Rather, Lord, the deceased had gone to bring his wife. It is said, Lord, that all had consumed liquor, and Lord, this is the case of the person, Lord, that deceased was not the forcibly Lord, asked Lord to consume liquor, and Lord, he was heavily drunk. Thereafter, he said, my Lord, that according to this PW5, there is no eyewitness. She says कि मेरी माँ उसके उनका पापा का पैर पकड़ी, and Lord, this appellant number 1 had assaulted. Lord had given Lord the had caused injury due to Lord with hard and blood found in the abdomen, and that Lord has caused death. My Lord, the doctor has conducted the autopsy, my Lord. Doctor has not found any, my Lord, the smell of, my Lord, the even liquor. No liquor has been found in the, my Lord, the stomach. And my Lord, she says that Lord, she has stated about this fact, Lord, to the police under section 161 कि उसको मम्मी जो है उसका पैर पकड़ी थी और ये विक्रम सिंह he had assaulted, and Lord, the father was Lord, the forcibly Lord forced to consume the liquor. This Lord, the statement she had not made under section 161 CRPC. Because my Lord, my Lord, I am in jail custody since 19/8/2014 for Lord more than 7.5 years, Lord. I am in jail custody. More than 7.5. There is no eyewitness, there is no recovery. Only Lord, the child witness.
The minor is eyewitness. The child witness is there.
Child witness may not be no doubt, Lord, the conviction can be recorded on the basis of the Lord deposition of a single witness, provided Lord that witness Lord must be wholly reliable. Lord, this is not wholly reliable because Lord, whatever she has stated before the trial court, she had not stated during the course of investigation before the policeman. So Lord, there is chance of not the tutor that she might have been tutored. Otherwise, she would not have exaggerated or added Lord something which was not stated by her during the course of investigation. So Lord, this Lord shows Lord the some doubt. Otherwise, Lord, except that Lord PW5, there is nothing against Lord this appellant. And Lord, they are not in jail custody Lord for more than 7.5 years. Lord, sufficiently they have been punished Lord by the custody.
He has replied all the questions of the defense.
Yes, my Lord, that is it. My Lord, I am not. My Lord, she has whatever she has stated, my Lord, regarding Lord the overtake committed by Lord the appellant, that has not been stated by her under section 161. The IO, Lord, they also said that. IO, Lord, that is the PW.
PW9. Alinder Kumar Singh.
This Lord, the ground has also been taken. Lord, internal page 11 and running page 18, my Lord, in the judgment. I am reading about the page 11, internal page 11. Rimjim Kumari PW5 was present at the place of occurrence. This court at the time of recording of the evidence had put her general question at para number 1. She could understand all the questions intelligently. In fact, on her cross-examination, the defense has also put a question to her to test the intelligence at para number 6. She could understand the question promptly and intelligently. Yes, it is true. This is not the finding of the court. Yes, it is true that this witness has stated that she had seen the Vikram Singh forcing her father to consume liquor, but no trace of liquor was found on the postmortem. It is also true that IO has stated that this witness has not at all told him that her mother had caught hold, her father and Vikram Singh had caught her of his head, but the IO has categorically stated that this witness has stated that she had seen the accused person dragging the deceased inside. So, my lord, this, my lord, this allegation which has been alleged, my lord, rather than the overtake, my lord, as it is committed by the appellant has been stated by the PW5 in the London trial court, my lord, she has not made, my lord, such a statement before the IO during the course of investigation. So, my lord, as per, my lord, then it appears that, my lord, she has aggravated such a story. Otherwise, she would have stated this story, this allegation before the IO also. So, my lord, considering, my lord, all the aspects, my lord, that this witness is not fully and fully reliable, Supreme Court says, my lord, that the child witness can be subjected to tutor. It cannot be ruled out. My lord, I am saying that for the purpose of bail, my lord, when these appellants have remained in custody for more than 7.5 years, more than 7.5 years, my lord, they are in real custody. My lord, there is no witness except of the child witness, my lord. So, my lord, at least this mother, my lord, is behind the bars also, my lord, she will take care of the child also, my lord, the doctor. And the doctor has not found, my lord, even a smell of, my lord, this liquor. Nothing has been found. There is no trace, my lord, in the postmortem report that deceased, my lord, has consumed liquor. And, my lord, there are 3 things. That, my lord, this deceased was, my lord, made senseless as per the case of the prosecution. He was heavily drunk. Then, my lord, certainly, my lord, in the postmortem, some, my lord, the trace must have been found by the doctor. That is not there. And, my lord, injury is not such that, my lord, the injury is not caused by any sharp weapon. My lord, it is apparent from the postmortem examination that deceased, my lord, has sustained injury on the abdomen. It might be, my lord, due to, my lord, the scuffle between husband and wife. Otherwise, my lord, if there would have been any, my lord, intention to commit murder, or it was pre-planned murder, then, my lord, some other weapon might have been used. Dr. Sapan Kumar Sarak, PW3, who had performed the postmortem on the dead body of deceased, has found the external injury.
Mr. Counsel, I am going to the case diary statement of that girl.
Pardon, Lord?
I am going to the case diary, the statement of the girl. In the statement of the girl has stated that नाना ने विक्रम मामा को पापा को मार दिए हैं.
My lord,
नाना के कहने पर मार दिए हैं. And just one line, the entire story what she has stated in her evidence is there in the case diary. Just one line in between is missing in the case diary. We doubt the integrity of the police officer also.
My lord, my lord, I am not the
praying. I know very well. I know very well our limitation that we cannot go to the case diary.
Yes.
The purpose of which I have seen this.
I know that my lords are aware of not this proposition of law. I am not saying that, but my lord, my lord may consider, my lord, at least the grant of bail, considering, my lord, this detention, my lord, of the appellants in jail. At least, my lord, my lord, out of 2, at least not the appellant may be granted bail, because, my lord, My lord,
Yes, Mr. Kashyap.
50%, my lord. So far, the appellant number 2, she is the mother. She has remained in custody for more than 7.5 years for the welfare of my lord, the daughter. Because my lord, now my lord, the child
This type of mother cannot be like welfare to the daughter.
she has lost her father.
The
But mother,
more the mother, this type of mother is kept out of the daughter is good for the daughter.
no, I think, my lord, that she has been sufficiently punished by remaining custody for about 2 years.
Nothing. Sorry. You have the concept for the appellate, Mr. A.K. Kashyap, senior counsel, the APP, full stop. The appellant has prayed to release them, the appellants have prayed to release them on bail after suspending the sentence, full stop. Earlier, their application was rejected, full stop. We have gone through the entire case diary, entire depositions and the judgments, full stop. We found that there is a direct allegation against this appellants committing murder of the husband of appellant number 2. Full stop. The child witness, that is the son or daughter of the deceased and appellant number 2, has narrated the story. Full stop. She is the eyewitness. Considering this heinous nature of crime, we are not inclined to release these appellants, release these 2 appellants on bail.
My lord, may I pray, my lord, that the paperwork may be prepared, my lord, the office may be directed, because they about the quarter.
This appellant will get liberty to renew, pray for early hearing of this appeal. Full stop. Next time, the office is directed to prepare the paperwork.
All right.
Obliged, man.
Serial number 5, Criminal Appeal DB 286 of 17.
In this case, my lord, I am appearing on behalf of informant, my lord.
Yes.
Yes, informant, why not bail? Why not bail?
Yes, why not bail?
Informant.
My lord.
Why not bail?
Yes, my lord. In this case, my lord, earlier on merit twice rejected, my lord. And there is direct allegation against this petitioner to assault the, my lord, the deceased on head, which is corroborated by the medical evidence also, my lord. And more so, he was, before trial, he was absconded, my lord. After 5 years, my lord, he is arrested by the police, my lord.
Yes, Mr. Kashyap.
My lord, my learned friend, my lord, has stated, my lord, all these facts, but my lord, he has not stated the fact what are the lacunae, my lord, in the case of the prosecution. My lord, he has, my lord, argued and submitted, my lord, by saying that, my lord, he has assaulted a direct allegation. My lord, my lord, I submit for lordship, my lord, that my learned friend is not fully correct. No doubt, my lord, in this case, my lord, the 6 witnesses, my lord, have been examined. My lord, PW 1, 2, and 4. 4, my lord, is the informant. My lord, the PW 3, my lord, the hearsay witness, Dr. my lord, PW 5, my lord, he has found, my lord, that was due to head injury. And my lord, the one DW, my lord, has been examined. And Purna Devi, she is the owner of the tempo. She has also, my lord, proved the exhibit A, which is, my lord, the complaint case, in which, my lord, another story, my lord, is coming forward, that in fact the deceased, my lord, had died due to, my lord, the sustaining injury, my lord, on his head. There was dispute between the parties regarding, my lord, the irrigation of land. That's why, my lord, this appellant, my lord, has been falsely implicated in this case. My lord, that is, my lord, the case of the defense. No doubt. Now, my lord, this so far, my lord, I will not, my lord, much, my lord, I will not argue, my lord, much, because, my lord, I may be, my lord, stopped by lordship also, and my lord, certainly, because, my lord, the earlier, my lord, heard, my lord, the application for bail, my lord, on the merit also. Once it was rejected, my lord, that is on 8/11/2017, 4.5 years ago, 4.5 साल पहले. And thereafter, the petitioner, appellant was refused provisional bail, refused grant of provisional bail, as what he had prayed that for treatment of his wife, he is in need of provision. That was what they rejected on 23/7/18. So, Lord, the only once, Lord, the prayer for bail of the appellant appellant was rejected on merit, considering, my lord, that, my lord, he is in jail custody for some less period. Now, my lord, he is in jail custody since, my lord, since 17/1/15, that is, my lord, for more than 7 years and 3 months. Allegation, my lord, against the petitioner appellant is, my lord, as per the case of the prosecution, apart from the, my lord, the defense case, that he is alleged to have assaulted on the head of deceased with farsa. My lord, may kindly see, my lord, the post-mortem report. The doctor has stated that the injury was caused by hard and blunt substance. My lord, in the FIR, there is no allegation कि उसको जो उलट करके फरसा को उल्टा तरफ से मारे. This is not the case of the prosecution. When, my lord, after seeing the post change, just to get it fitted with the case of, not the prosecution, after seeing the post-mortem report. When the post-mortem report has not completely belied the injury, not caused by sharp division, then, my lord, this has been stated by the informant for the first time in the trial court कि गणासा का उल्टा तरफ से मारे. That is not, my lord, in the FIR. That's why, my lord, therefore.
FIR is not the encyclopedia.
No, my lord, so far manner of offense is concerned. वो जो इतना तो कह रहे हैं कि गणासा से मारे, गणासा के उल्टा तरफ से मारे. नहीं, हम ये बोल रहे हैं गणासा से मारे. What prevented him, my lord, to say कि हाँ साहब गणासा को उल्टा तरफ मारे? My lord, if now, my lord, I am coming to, I am, my lord, making my submission on 2 grounds. This is, my lord, that there is nothing in the FIR. This story has been changed after seeing the post-mortem report. Now, my lord, if I believe, for the sake of argument, my lord, for the purpose of bail, my lord, this, my lord, the deposition of, my lord, the informant and his brother, my lord, that the appellant, my lord, had used this, my lord, the blunt portion of, my lord, the ganasa in order to assault, my lord, the deceased. Then, Lord, certainly I can make a case with your lordship, my lord, subject to your lordship's kind consideration, that there was no intention to commit murder. Otherwise, if that is the situation, then, Lord, the person, why, Lord, if he has got intention to commit murder, then he will, Lord, choose, Lord, the sharp portion, not, Lord, the blunt portion. So, my lord, in that case also, the appellant, Lord, has got no intention to commit murder, then, Lord, the case may come under section 304, part 2. And for that, Lord, the appellant has remained in custody for more than 7 years, my lord, since 17/1/15. My lord, I am aware of the judgment, several judgments of the Supreme Court, my lord, that under section 304, part 2, my lord, the maximum, my lord, the 5 years sentence is awarded. I am, Lord, this is not a case of pre-planned murder. There are 2 versions, my lord. The DW1 says the complaint has been, Exhibit A shows, my lord, deceased had died due to, Lord, the... My lord, that complaint was lodged by DW1 Annapurna Devi. She is the owner of the tempo. She said कि owner ये लेकर के owner ये tempo जा रहे थे and owner ये tempo पलट गया था. ये चीज के लिए कंप्लेंट हुआ था पहले और उसमें सस्टेन इंजरी सस्टेन हुआ था ऑन दी हेड. इसीलिए जो डॉक्टर पाया है हार्ड एंड ब्लड सब्सटेंस. लेकिन केस बनाए तो केस बना करके हमको हुजूर नेक्स्ट ये था एग्जिबिट ए सी एच प्रूफ डॉट DW1. DW1 पेज 9 सी सेज दूसरी तरफ द्वारा अपने बचाव में प्रतिरक्षा मतलब इंटरनल पेज 9 पैराग्राफ 11 ऑफ द जजमेंट. दूसरी द्वारा अपने बचाव में प्रतिरक्षा साक्षी संख्या 1 अन्नपूर्णा देवी का परीक्षण कराया गया है जो औपचारिक साक्षी है जिन्होंने परिवार पत्र संख्या 628/10 की प्रमाणित प्रति सर्टिफाइड कॉपी को प्रदर्श ए रूप में साबित किया है. प्रदर्श ए परिवार संख्या 628/10 के अवलोकन से स्पष्ट होता है कि परिवादिनी मसमात अन्नपूर्णा देवी पति डेट my lord,
where is the document? I'm not getting that.
11/8/10 का तो है. That note I get from the judgment, paragraph 11.
Not getting it.
जो ये कंटेंट्स है कंप्लेंट का वो जो दैट इज नॉट बीन मेंशन्ड इन द पैराग्राफ. Moreover, my lord,
The document. Go to the document.
document my lord, the picture. I am not appearing in virtual mode, my lord. Otherwise,
11/8/2010.
हाँ 2010 का ही तो है अब जो इसमें पैराग्राफ 11 में मतलब the real fact has been mentioned by this Annapurna Devi. She has not been detained. She has come before the honorable court, before the United Trial Court.
Who is
She has
she?
put the document also as Exhibit A. But there is something, my lord, that the doubt, my lord, is there. Because, my lord, this postmortem does not, my lord, corroborate the allegation alleged not by the prosecution. It is not the test, not is there to just to test not the veracity of not the statement of the witnesses during the course of trial. Otherwise, not the anybody can change not the story after seeing the postmortem report, and that has been done in this case also, my lord. Otherwise, a eye witness lord he will say कि कहाँ पर मारे, किस चीज से मारे. अब ये जब देख रहे बाद में इनको याद पड़ गया जब ट्रायल में किन्हीं ने उल्टा पासा गणासा को उलट करके पासा से मारे, तो मुझे कहाँ इंटेंशन था मेरा. इतना कोई आदमी जब यहाँ इंटेंशन होगा मर्डर करने का, हुजूर सीधे शार्प कटिंग वेपन का शार्प पोर्शन यूज करेगा या बचा करके उसको मारेगा जिससे पासा से, ब्लंट पोर्शन से. ये हुजूर है स्टोरी ये चेंज करने के लिए कि ऐसा नहीं हो कि इस पर हम लोग लगाए हैं जबकि आई विटनेस नहीं है कि गणासा से मारा और गणासा की इंजरी नहीं अगर पोस्टमार्टम में है तो बच जाएगा.
What happened to this complaint?
My lord,
Finally, what happened to this complaint?
my lord, I could not get not this information because not this I have also not gone through.
Get this information.
My lord, the record will show because the record is here, and my lord, from the judgment, my lord will find further एक paragraph 11 भी है.
This is an alibi.
No, this is not the alibi, my lord.
Yes,
This is
that you have not committed the murder. That you have not committed the offense.
This is the, my lord, the fact that the deceased, my lord, has sustained injury
By some other means. By some other means.
नहीं टेम्पो पलट जाने से. ये इस पर है हमारा जो नहीं कि हम एलिबाई का ले रहे हैं, एलिबाई के नहीं जो है कि ये जो प्रदर्श एक के अवलोकन से स्पष्ट होता है.
Defense that you have not committed this murder as he has sustained injury after she met with this person met with an accident.
जी हाँ, ये जो है इंटरनल पेज 12 में और पैराग्राफ 15 का सेकंड पैराग्राफ में जो देखा जाएगा या जो हम पढ़ते हैं आज हुजूर का आवाज बहुत क्लियर नहीं आ रहा तो थोड़ा सा सुनने में भी दिक्कत हो रहा है. प्रदर्श एक के अवलोकन से स्पष्ट होता है कि दिनांक
not directly saying that it may be taken over another day.
Today, we are not able to hear the voice clearly. That we are getting the problem. चाहे तो ये mask लगा.
Most probably because of the mask.
Because of the mask, yes, my lord. Otherwise, my lord, the case maximum, my lord, the case comes under section 304.
So, what is the minimum punishment? What is the minimum punishment of 304 as per the statute?
304 part 2, my lord, the minimum maximum 10 years. Minimum
Maximum is 10 years. There is no minimum.
No, my lord, the
there is no minimum.
There is no 10 years maximum, 10 years or less than 10 years. My lord, there are judgments. My lord also is party to the judgments also, in which my lord have heard the bill finally, and my lord has been pleased to award the sentence, lord, under the 304 part 2 for 5 years, 6 years. Lord, he has remained custody for more than 7 years, my lord.
Okay, take on. Third, learned senior advocate appearing on behalf of Mr. Secretary. Yes, Mr. Sanjay Kumar.
My lord.
Admittedly, there was a land dispute.
No, there is no land dispute, my lord, regarding, my lord, पानी पटवन के लिए हुजूर.
No, there is a dispute.
My lord, my lord.
Irrigating the land. And suddenly there was a dispute, and this dispute boiled into this incident. We heard the counsel for the appellant and heard the counsel appearing on behalf of the state assisted by the counsel for the informant. And learned counsel for the appellant's office, now the appellant has remained in custody for
Since 17/1/15, my lord.
But my lord, may I submit one thing, my lord? He was absconder for 5 years, my lord. It is admitted position, my lord.
More than 7
years.
years.
He
More than 7 years.
submitted that even if the prosecution case is taken on its face value, the case would be at best under section 304 part 2. He submits that from the FIR, it is apparent that there was some dispute in respect of irrigating the agricultural land when the occurrence had taken place. And it is further submission that the deceased, it is further submission that from the prosecution case also it is quite clear that though the appellant was holding a sharp cutting weapon, but the assault was from the blunt side, which would clearly suggest that there was no intention to commit violence. Next, the counsel appearing on behalf of the informant submits that the appellant was an absconder and he was arrested after 5 years. Next, with a resume, considering the nature of the assaults and the fact that the appellant had, and in fact that assault was from the blunt side of the weapon, and the appellant has remained in custody for more than 7 years. We are
Yes, ma'am.
inclined to suspend the sentence and release the appellant on bail, subject to a condition that he will appear and mark his attendance before registrar so and so once in 3 months till disposal of this appeal. So it is made clear that if he doesn't appear in, if he fails to appear, his bail should be cancelled and appropriate steps should be taken to rearrest him. Further, one of the bailers should be a close relative who will file an undertaking before the court to ensure appearance of the appellant once in 3 months before the registrar.
Obliged.
Serial number 6, criminal appeal DB 308 of 17, Mr. Tejo Mistry.
May I please, Malaj?
Yes.
Malaj, in this case, earlier my lords had asked for the state to inform whether victim compensation was paid or not. This is the same case, Malaj, where 5 lakhs was directed by my lords and Honorable Justice H.C. Mishra, which was not
Puncturing of the
paid.
eye.
My lord?
The puncturing of the eye of the victim.
Yes, my lords. Yes, my lords. Same case.
Yes, yes. Victim compensation has been paid or not? Who is for the state?
Lordship, I appear on behalf of the state, Lordship.
Victim compensation has been paid or not?
नहीं हुजूर, इसके बारे में इंफॉर्मेशन नहीं मिल पाया है हुजूर. एक शॉर्ट इंडल्जेंस.
Have you sought for the information?
Lordship, I inquired, Lordship, but they were not in a position to tell whether it has been paid or not. Lordship.
You have inquired from whom?
From the officer in charge, Lordship.
Officer in charge is not the person to give you information. You know, let this case after 2 weeks.
Lordship.
The Secretary, Jharkhand Legal Services Authority will inform this court to whether any steps have been taken to pay victim compensation to the victim or not. If the victim compensation has been paid and of the court any steps have been taken, the Details of the steps which have been taken should also be informed this call.
Malaj, may I also pray one more thing, Malaj?
Yes.
Since this is a matter referred through Jhalsa, Malaj, the period of custody undergone, Malaj, that may also be ascertained through Jhalsa, Malaj, because I don't have any connection with the appellant to find out how many days he's been behind bars.
Who has engaged you?
Malaj, it has come through
Custody
Jhalsa
report
only.
is there, Lordship.
It has come to Jalsa, you have this information from Jalsa.
Malaj.
Whatever doubt you have, you can definitely write. It is well within your domain to ask for Jalsa. And Jalsa is bound to submit you that.
Lordship.
Serial number 7, Criminal Appeal DB 487 of 17, Mr. Prashant Kumar Sahu, Mr. Abhijit Kumar Singh for the petitioner.
Yes, my lord, I am appearing in this case, my lord.
Yes.
Yes, my lord. Earlier, my lord, on 1/11/2017, the bail application of the petitioner was rejected, my lord. And thereafter, my lord, the present application, fresh application has been filed, my lord. My lord, the appellant, my lord, he happens to be the husband of the deceased, my lord. So far as the case is concerned, your lordship will take into consideration the appellant has been convicted under 302, not under 304B, my lord. My lord, so far as the 302 materials are concerned, the circumstances which have been proved by the prosecution and the story which have been propounded, my lord, there are two parts of the investigation which has been collected by the investigating officer. One, the statement given by the relatives, my lord, which has been taken into consideration by the learned trial court. But your lordship, only one thing, my lord, which I intend to brought to your lordship notice, my lord, that the only fault which has been done, my lord, in the present case, that she has committed suicide, putting herself in front of the train, my lord, and immediately thereafter information was given to the informant and the family member of the deceased. They came thereafter, my lord, the cremation was made. Subsequently, on the next day, my lord, the present FIR has been done. My lord, that will appear from the statement of the IO during cross-examination when he has recorded the statement of 6-7 persons, my lord, but those witnesses have not been examined in this case, my lord. PW4, there are only 5 witnesses in this case. PW4 is the IO, my lord. Kindly see for a moment, my lord, so far as that statement is concerned. Because the story is otherwise, my lord, so far the prosecution case is, my lord, that the brother of the petitioner demanded some money, my lord, and something, my lord, the car itself, my lord, which has not been fulfilled. Subsequently, on the date of previous to on the date of occurrence, the informant himself came to the village. He met with the victim, the deceased itself, my lord, and then he went away. In the night, my lord, at 9 p.m., my lord, he was informed by the appellant, my lord, that he is seriously ill and he is hospitalized in BGH. This is the prosecution case, my lord, so far as the prosecution part is concerned. They went there, they did not found. In the morning, they come to the house, my lord, and the house was found to be closed. Nobody was found there in itself. My lord, this is the case of the prosecution. But your lordship will take into consideration so far as the statement is concerned. My lord, in this case, one more fact, my lord, the charge has been framed 304B and subsequently 302. My lord, the appellant has been convicted not under 304B but under 302, my lord. Therefore, it is to be seen, my lord, that whether the statement, my lord, the kindly see, my lord, PW4's cross-examination, paragraph 2, my lord. Just I am reading, my lord, so far at that part.
Alternating charge was also framed under section 302.
My lord, therefore, I am submitting, my lord, initially the charge was framed under 304B, my lord. Subsequently, my lord, the 302 charge has been framed and conviction has been made. No finding has been given under 304B, my lord. So far as that part is concerned, the conviction has been made and sentence has been made under 302, my lord. Therefore, the evidence which is there, my lord, which is to be taken into consideration, my lord, that becomes important, my lord, for the purpose of holding guilty to the appellant, my lord, under 302, my lord. My lord, just your lordship, kindly see, my lord, for this moment, my lord, PW4 statement.
Mr. Anil Kumar, PW4 is the
IO, my lord.
PW4 is the IO.
My lord, he has recorded of those persons, my lord, and what statement has been given, that has been recorded, my lord. And this statement is corroborated by DW2, my lord. The DW2 has been examined in this case to corroborate so far as this statement is concerned. मतलब काइंडली सी my lord, डायरी में इस बात का जिक्र नहीं है कि मैं इस घटनास्थल पहुंचा, वो किस घटनास्थल का पहचान कराया. मृतिका मालती देवी के ससुराल घर के अगल बगल के 5 गवाहन सनिचरिया देवी, गोविंद महतो, संतोष महतो, महेंद्र महतो, सुनीता देवी का बयान लिया था, जिसमें वे सब इस बात का जिक्र किए थे कि घटना के पिछले दिन प्रेसिडिंग डे मृतिका के पिता व जीजा उसके ससुराल घर आए थे। जो इन्फॉर्मेंट इज एडमिटिंग मिला, वो उसे काफी समझाए बुझाए, वो जब वे चले गए तो मृतिका गुस्से में आकर रेलवे लाइन में जाकर ट्रेन से कट गई। जब उस बात की सूचना मृतिका के मायके वालों को दी गई तो वे लोग मृतिका के ससुराल आए व उसके लाश को जंगल में ले जाकर जला दिए। जिस गाड़ी से वे लोग आए उसी से अपने घर लौट गए। गवाह ने मेरे समक्ष अपने कथन को बताया कि मृतिका को उसके ससुराल वालों से घरेलू मामले को लेकर झगड़ा विवाद होता था एवं मारपीट भी मृतिका के साथ किया जाता था। यह कहना सरासर गलत है कि मेरी अनुसंधान त्रुटिपूर्ण है। मतलब दिस स्टेटमेंट हैज बीन गिवन बाय द विटनेसेस, देयरफॉर देयर आर टू स्टोरी my lord which has been collected during course of investigation. मतलब these witnesses has not been examined. Now your lordship, this statement has been given by DW2 also my lord.
What?
So far as this part is concerned, my lord, she has committed suicide, putting herself in.
How did he know that she has committed suicide? Because he has not seen this Malti Devi going out of house.
My lord, this is the statement, my lord, which has come, my lord. Therefore,
it's your witness. You say that Malti Devi has committed
these are
suicide.
the witnesses.
And you are relying upon DW2.
No, my lord, these are the.
I am asking you that how does DW number 2 know that she has committed suicide?
Therefore,
Because he has not seen her leaving the house.
My lord, therefore, I have said, my lord, so far as the during investigation, the statement of these 5 witnesses has also been examined by the investigating officer. My lord, this statement, my lord, has been recorded under 161 also by the investigating officer. Therefore, I told, my lord, I am submitting, my lord, to that effect. My lord, it is not as such, my lord, DW2 is the only evidence. Therefore, my lord, there are 2 stories which is out, my lord. I am not saying, my lord, which one is true. But the fact remains, my lord, there are 2 stories which is coming out. If at all, my lord, the statement of 5 witnesses have been examined by the IO, my lord, who are saying that she has committed suicide and thereafter the cremation has been done in presence of the informant party, my lord. It is not as such, my lord, they were not present. This is the specific statement which has been given by them.
So if a person dies by committing suicide, was it not your duty to inform the police about this unnatural death?
My lord, the family members, my lord, so far as the deceased family members, they have been called upon, my lord, they were informed, my lord. Thereafter, my lord, the cremation has been made.
They deny this.
My lord, therefore, I am saying, my lord, there are 2 parts of the statement, my lord. One, my lord, the investigating officer has collected the statement of 5 witnesses. My lord, they are saying so, my lord. And there are 1 interested witnesses, my lord, who are saying otherwise on the next day. Therefore, my lord, so far as that part is concerned, I am submitting to that effect. There is a doubt, my lord, so far as the story is concerned. And in the FIR, your lordship will see, my lord, so far as the demand is concerned, it is against the brother, not against this petitioner, which has been improved during course of investigation, during course of trial that the petitioner has demanded. If this is investigations evidence would not have been there, my lord, then definitely, my lord, the probability is to be seen with respect to the reliability of DW2 only, my lord. But the fact remains, my lord, that during investigation, 2 story has come. And he is in custody for more than 6 years, my lord. For holding guilty, my lord, so far as the 302 is concerned, my lord, there should be some circumstances, my lord. The circumstances are appearing contrary, my lord. एफआईआर में वो बोलते हैं हुजूर कि मेरा भाई गया था उनके घर में, वहां से उन लोगों ने डिमांड किया था रंगीन टीवी और 10,000 रुपया भाई मांगा था। एफआईआर में तो यही स्टोरी है।
Now the counsel for the appellant heard senior advocate Sri Kumar on behalf of the appellant. The learned counsel reduced the prayer for bail on behalf of the appellant. And all the appellants.
Appellant number 1, my lord.
Appellant number 1.
has been granted bail, my lord.
Appellant number 1 is the husband of the deceased. The counsel for the appellant submits that the appellant has been convicted under section 302 of the Indian Penal Code. But from the prosecution evidence, it would be quite clear that the prosecution has failed to prove the charge beyond all reasonable doubts. First up, if at all the prosecution case is to be taken on its face value, then the only material which is against the appellants are that the dead body was cremated at the dead of the night in absence of the family members. So he submits that this cannot give rise to a presumption that this appellant has murdered the deceased. So he lastly submits that the appellant is in custody since.
My lord, since the date of judgment, my lord, prior to that, my lord, he was remained in custody for 14 months, my lord. About 6.5 years.
Give me the period. Where have you stated?
6 June 2008 to 9/9/2009, my lord, during trial. And
from custody from 6/6/2008 to 9/9/2009.
And on 2017, again, he is taken. Thereafter, my lord, 28/1/2017, date of judgment, my lord.
28/1/2017,
my lord.
2017 till date. Full stop. So 8 years he was on bail.
In trial, my lord, he was on bail.
Full stop. The aforesaid submission next, and the aforesaid submission also suggests that during trial, he was also on bail for a substantial period, and he has never misused the aforesaid privilege. Considering the aforesaid fact that he was on bail for a substantial period during trial, and now he is in custody for nearly
5 years, my lord.
5 years. That is 5 years after conviction. We are inclined to release the appellant on bail.
Obliged.
Once. Yes,
Serial number 8, criminal appeal DB 561 of 17, Mr. Naveen Kumar Jaiswal for the petitioner.
Serial number 8.
Yes.
May I please? That is 1506.
No.
Your Lordship, in this case, I am SK Samanta, Your Lordship. Your Lordship, this case may kindly be passed over for the day.
Doesn't matter which case you are playing for, SK Samanta.
Criminal Appeal 561 of 2017.
On the request of the government counsel for the appellant, this case is adjourned.
Your Lordship, केवल पास ओवर फॉर द डे आज आ रहे हैं योर लॉर्डशिप, नेक्स्ट टाइम जब भी रहेगा रहेगा।
ठीक है, नेक्स्ट टाइम जब भी रहेगा रहेगा।
Serial number 9, criminal appeal DB 628 of 17, Mr. Ganesh Ram for the petitioner.
My lord, I am appearing for the appellant, my lord, sole appellant, my lord. Earlier, the for bail of this appellant, my lord, dismissed on 25/7/2017, my lord, and now he is in custody, my lord, more than 7 years, my lord. More than I have stated in para 6, my lord, He's in custody since 13 to 2015, my lord. So he is custody for more than, my lord.
The girl was 6 years. The oral evidence corroborates. The FSM
My lord.
report corroborates. Everything corroborates. So,
that is there, my lord. May I kindly consider the statement of the victim, my lord, PW2, my lord. PW2, my lord. मैं दादी के घर आंगन में सोई थी, कोई आया, पता नहीं चला कि कौन आया था. In chief, my lord, and after that she said about the appellant, my lord, and the last in cross examination, my lord.
you have damaged your case in the cross examination, I think.
शाम को घर में अंधेरा था, हम सो रहे थे, मेरे में उंगली डालकर भाग गया, मैं उसे पहचानी न थी. That is the statement of the victim, my lord, and there, my lord.
Just a minute, let me find out the evidence. PW?
2.
What is the second copy? It's a division bench matter.
मैं दादी के घर में आंगन में थी, तभी कोई आया, पता नहीं चला कि कौन आया था. And thereafter she said against the appellant, my lord. She said, but in chief, my lord.
You read that. You read thereafter. He says that.
Thereafter she said, my lord, but in cross examination, my lord, also there is very clear that in cross examination.
Not cross examination. She identified you to be the person who has committed the occurrence.
शाम को घर में सो रहे थे.
Doctor found so and so exhibit 5 is trying to disclose the blood stain coming on so and so by the who was caught by the victim before forensic lab.
My lord. And also there is delay in lodging the FIR, my lord. There is delay of 7 days, my lord. There is delay in lodging the FIR, my lord. 7 days, my lord. Date of occurrence is 6/2/2015, and date of
Statement of the mother.
Statement of mother is also there, my lord. She said against the appellant, my lord, and stated that I have seen the alleged occurrence. That is PW3. But there is delay in lodging the FIR, my lord, 7 days, my lord. And I am in custody more than 7 years, my lord. PW3 is informant, mother of the victim, my lord.
The appellant renews his prayer to release him on bail after suspending the sentence. The appellant has been convicted for committing offence punishable under section so and so. The victim girl, who is aged about 6 years, supported the prosecution case. The mother of the victim, who is PW number 3, has also supported. The forensic report also supports the occurrence. Considering the sentence is for life. Considering the opposite fact, we are not inclined to release the appellant on bail. Dismissed. Next paragraph. The appellant will be at liberty to pray for early hearing of this appeal. Full stop. Office is directed to prepare the paperwork.
Oblige, my lord.
Serial number 10, Criminal Appeal DB 863 of 17, Mr. A.K. Chaturvedi for the petitioner.
My lords, I pray for not today, my lords, in this case, my lords.
Okay.
My lords, in this case, earlier I was directed to inform to this honorable court, my lords, with regard to the antecedent of this applicant, my lords.
Yes.
That was the earlier for that.
Okay, on the request of Mr. Chaturvedi, this case is adjourned for 1 week or 2 weeks.
It's only 4 weeks time, my lords.
4 weeks.
Yes, ma'am.
The rest of the case will remain on board. We will take it up next Wednesday. We will be sitting on every Wednesday, second half.